A managing partner, Bankole-Apena and Co. Abibat Bankole-Apena joins me on the news at 1 to discuss the state of emergency in Rivers State. It's good to have you join us on the news at 1. We've seen some concerns about the president's proclamation of a state of emergency in Rivers, but with the legislative arm, the Senate and the reps ratifying that decision, does it put to rest some of the questions about the illegality of this process?
Exactly, madam. You just spoke my thoughts. As at the time President Bola Ahmed Tinubu made the declaration, there were so many political comments from different angles on the legality of the proclamation. But looking at Section 305 of the Constitution, the Constitution has made it clear that once the president makes such proclamation, within 2 days, the power shifts to the National Assembly, either to ratify or approve such proclamation or otherwise. And the National Assembly have done so rightly yesterday by not only upholding the proclamation, but also giving recommendation as to what will likely bring peace to the River State very shortly. One of such recommendations is the presentation of a reconciliation committee to be done by notable national figures to go to River State to speak to the warring parties and to bring peace to the state. I think the ratification has answered many of the questions, though some still remain unanswered, as seen from different commentators, even as at yesterday.
And talking about some of the unanswered questions, deriving from the Supreme Court judgment, which said that Rivers State has been without government for some weeks now. On what basis will the governor now be standing for some of the decisions he made afterwards?
Now, it is true that once the Supreme Court, the judgment of Supreme Court is final, and once the Supreme Court has said something, what parties ought to do is to comply with the decision of the Supreme Court. And as such, it seems that the position of the president is even in line with the Supreme Court, the Supreme Court judgment. What the president ought to have done, or I mean the governor ought to have done after the judgment, was to look for ways to implement that judgment politically within the party before allowing things degenerate to the level of the president proclaiming state of emergency.
I mean, the questions would have been how, other parties were actually interested in, making peace. When you mentioned that, the governor himself should have tried to make peace after that judgment. But it's been said that similarly, Fubara remains the governor of that state. Does it suggest that he still has the immunity of a sitting governor? If he has,
no.
To what extent can this be consummated? But if he does not, what's the implication of this?
No, I think he does not. That has been settled in the case of Plateau State and Attorney General of the Federation.
Right.
For the period someone is being suspended, such person cannot come and claim to be the governor of a state. Should, in case the president or the National Assembly decide to truncate the proclamation, maybe in days' time or in few days' time, in few weeks' time, then he can return to his position as the governor of the state. For example, I saw a new suit filed yesterday by a particular citizen of River State on behalf of the governor. And then the question now comes, does this person have local standard? The same way the question would come, that as at this time, a suspended governor, could you call that person still a substantive governor of a state? I think not. In my humble opinion, for the period for as long as the governor is under suspension, such person or Governor Fubara cannot validly claim to be governor of the state.
So I wasn't really talking about, he acting as the governor. I'm talking about the level of immunity he has within this state of emergency. But I'm sure we'll have more time to discuss that much later. Managing partner, Bankole-Apena and Co. Abibat Bankole-Apena. Thank you for joining us on the news at 1.
Thank you.